Good morning, ladies and gentlemen. Welcome to today's webinar. Our topic of today is, again, the change of use of real estate and how to optimize properties. In other words, how to best repurpose properties. Today's webinar is the last webinar in the series of webinars that Wolf Theiss had on the topic, where we covered basically all the countries in which our firm is active in as a legal advisor. Today's expert panel with me is Ms. Marija Lalin from our Croatian office. I see her on the, now she's, her picture, you see her picture below my picture. Next one is Mr. Marko Tesanovic of our Serbian office, heading our real estate practice there. And last not least, there is Ms. Neja Voncina from our Slovenian office. So this is today's expert panel, and these are the really important people whom you will be meeting virtually today. Now just to give you a very brief introduction into the topic. What we see, what is going on in today's real estate world is a kind of, I would say, seismic shifts going on, or tectonic shifts in the world of real estate, in terms of that what was high in demand in the last years may not be as much in demand for the years to come. Now, this has various reasons. One certainly is the COVID crisis and its effects, but there is clearly ongoing developments that have fueled this larger scale development that is going on. For instance, the shift from brick and mortar retail to virtual retail. The changes that are going on in the hotel world on grounds of, not at least on grounds of travel restrictions that we see today. Changes in the world of offices, where the COVID crisis has accelerated the trend towards home office, and where we see that office sizes are changing, and increasing demand for logistics that also has various reasons, and clearly a development that we see throughout all larger European cities, dramatic increase of the need for additional housing. Now, all of this leads to the fact that there is types and classes of real estate where a repurposing is being considered, rather than waiting and holding out and waiting whether demand will again be where it was. People think about how to convert, for instance, a non-functional shopping mall into alternative types of uses, or conversion of hotel space that may not be needed for a longer period of time into apartments and other things. Now, this all can be subsumed under the topic of repurposing of real estate, and clearly this is something that triggers various questions, inter alia legal questions. So as a kind of a little warm-up exercise for today's webinar, what we did is we prepared two questions that are aimed at finding out what your as the audience's views is on this topic. You see these questions in our chat function. So allow me to ask you whether and for which property types you see the greatest need to find new, different, or alternative uses for the future. Multiple answers are possible. Categorization, you will see, is basically following classical categories. We distinguish between retail, hotel, office, logistics, residential. Again, the question, for which property types do you personally see the greatest need to find new ideas for in the future? Again, we would invite you to click at the categories where you see this need. Now, allow me to check. I should have received your responses by now. Clearly it is retail and office for which obviously you see that there is the need to think about alternative uses. Now, another thing that would be of interest for us to learn about is whether or not your company currently is actively dealing with such a project to change the use of an existing property and to repurpose it. Here the answers is just a simple yes and no. Yeah, just learning about the level of your personal involvement into the topic. Yeah, obviously, this is more of an academic interest for you to look at rather than the issue of being personally touched by the topic of repurposing of real estate. Now, that shall not keep us from diving into country specifics on this topic, and our starting point will be Croatia. Marija, maybe you can give us and our audience a little bit of background as to whether or not and how easy or how difficult it is in Croatia to change the current use of a given property.
Yes, of course. For the beginning, thank you, Peter, for the introduction. I'm really honored to be participating in this webinar and to be able to speak on the topic of the repurposing of the real estate in Croatia. To begin, under the Croatian law, the use of the buildings is legally determined by the operating permit. That means that operating permit, which has been issued for a certain building, determines how the respective building should be used. For example, as an office building, residential building, etc. In case the building is used without the operating permit or contrary to the operating permit, the administrative penalty may be imposed for both the investor and the owner, and the amounts may be up to the 20,000 euros. Notwithstanding the fact that the operating permit legally determines how the building has to be used, under the Croatian legal system, it is generally possible to change the current use of the real estate. There are two main legal acts on the national level that regulate the repurposing of the real estate. These are Construction Act and Spatial Planning Act, of course with their bylaws. However, it is necessary to highlight that the local zoning regulations are also important and relevant as well, as the spatial plans determine which type of building should be built in which area. As I have already mentioned, two main national acts regulate the repurposing of the real estate. In general, those acts are pretty well and they explain well the procedural steps that have to be taken in order to achieve the repurposing of the real estate. However, we should highlight that in practice is always present the element of interpretation of rules and possibilities of construction and use of the building. Also, the case-by-case approach cannot be excluded. That means that not all possible cases and situations are regulated by the law, and certain authorities, by that I mean mostly local authorities, may have different approach and different practice in resolving those cases. When we speak about the repurposing of the real estate, Under the Croatian law, generally, it is not relevant the purpose of the change, precisely whether if it will be, for example, the change from residential to office use or vice versa. What is crucial is whether under the procedure of change of use of real estate, certain construction works or the construction activities that require obtaining mandatory construction permit should be carried out or not. On that depends how the procedure for change of use of real estate should be conducted. So the first situation is when, in order to achieve the repurposing of the real estate, the owner must undertake certain construction works or the construction activities in order to achieve a new use of the real estate. In those cases, the owner must obtain new or the amended construction permit following the new operating permit, which will allow him or her to use the building for the new use. It is necessary to highlight that the construction permit is really important because without the construction permit, the owner cannot begin with construction works. With respect to the operating permit, the procedure is that the owner or the investor submits the request, precisely the application for issuance of the operating permit to the relevant authorities, along with all necessary documentation prescribed by the law, which is basically, in short words, the copy of the construction permit, also the final report of the geodetic engineer, then also the evidence that the building is located on the building plot which is in line with the construction permit, and also the evidence that the building plot is formed within the cadastral registry. After all the relevant documentation has been submitted, the relevant authorities should conduct the technical inspection, which purpose is to determine that the building is built in line with the construction permit. Those inspections should be conducted within 30 days as of receipt of all relevant documentation by the relevant authorities, and the operating permit should be issued within 8 days as of finalization of the inspection, of course, considering that all relevant prerequisites have been submitted. When we talk about the time frame which is necessary in order to achieve a repurposing of the real estate, the usual practice and the publicly available data of the relevant authorities shows that for each permit, it usually takes between 3 to 6 months to obtain each relevant permit. Of course, this time frame may differ in every specific case. But also we have some shorter procedure in order to achieve a repurposing of the real estate. This is a situation when, in order to achieve new purpose of the real estate, it is not necessary to perform construction works that require obtaining the construction permit. For example, this is a situation when you change the apartment into office use. In those cases, there is, in most cases, not necessary to conduct certain construction works. And in those situations, the owner or the investor must obtain the permit for change of function and use of the real estate, by which permit the relevant authorities approve the new use of the real estate. And this procedure is much more shorter. The procedure is basically that the owner or the investor submits the application with all relevant documentation, which is basically the proof of its ownership, the operating permit or some other evidence that the building may be used. Also the certification of the relevant authorities if owner requests the change use of the cultural property, which is registered in the cultural heritage of Republic of Croatia. Finally, when all relevant documentation has been submitted, then there is also one more requirement, that the new use of the real estate should be in line with the spatial plans, and also that the real estate fulfills all necessary requirements that are mandatory by the relevant legislation for its new use. And in order to determine whether real estate complies with all that necessary legal requirements, also the relevant ministry conducts the technical inspection and issues the certificate thereof. When we talk about the time frame of this simpler procedure, we can say that the average time frame is also between 3 to 6 months in order for the relevant authorities to issue this permit for change of function and use of the real estate. So consequently, I will sum up these two procedures. So the crucial element is, in order to achieve repurposing of the real estate, is to distinguish whether the construction activities should be carried out or not. If not, then the procedure is simpler. The owner must obtain the permit for change of function and use of the real estate. And if construction activities are necessary, for example, if you change apartment building into production facility, you will obviously need to perform certain construction works. And in those cases, the owner should obtain new or amended construction permit. And according to the Croatian law, the procedure for obtaining the amended construction permit is basically the same as the one for obtaining the new construction permit. And of course, along with the new or amended construction permit, the owner would have to obtain also a new operating permit, which will allow him or her to use the building for its new purpose. So this procedure takes much longer time. Of course, a case-by-case approach cannot be excluded when we talk about the time frame of the repurposing of the real estate, and it really depends on the circumstances of every specific case in which time frame the repurposing of the real estate will be achieved. I would like also to emphasize that and to highlight that the spatial plans are also important and relevant as well, because there might be a problem when repurposing is not in line with the spatial plan. In those situations, Croatian law enables to anyone, by that I mean to all individuals and to all legal entities, to submit their proposal for amendment of the spatial plan. Those proposals will be registered as proposal for expert analysis, which purpose is to determine whether there are legal grounds for commencement of the procedure of amendment of the spatial plan. If that procedure is approved, the proposal of the spatial plan should be publicly announced and the public consultations should be carried out. Within that public consultations, all participants may submit their suggestions, proposals, but also objections on the proposal of the spatial plan. Once the public consultations are finalized, the relevant authorities will prepare the minutes on the public consultations, which minutes contain all received proposals and objections, but also explanations of the relevant authorities why certain proposals of the participants have been approved, have been partially approved, or have not been approved. And based on that, the relevant authorities will prepare the final proposal of the spatial plan. Spatial plan on the regional level, by that I mean on the level of the county, adopts the relevant representative body of the county, which is County Council, and the spatial plan on the local level or on a city level adopts the representative body of the city or of the municipality, which is practically the city council or the municipality council. Nevertheless, if an amendment of the spatial plan is not in line with the investor's will and it's not in line with its plans, it may always initiate the administrative procedure before the administrative court. And also there is always a higher instance, the constitutional court, before which the individual may submit the claim in order to determine whether the amendments of the spatial plan are in line with the Constitution and in line with the relevant legislation. And that will be everything from the Croatian side of the presentation. Peter, if you have any questions, you are free to ask.
No, thank you, Marija. I think that this was a really brilliant summary. And basically, most of the points that I had wanted to ask Marija, you answered anyhow. So I think probably, I mean, it was really very condensed information that you gave, but I think you gave an impressive, concise summary of what the Croatian law is. So maybe just to briefly touch on the last point of your presentation, Marija. If I may kind of very simply summarize kind of my understanding of how things work in Croatia, it seems that as long as you are moving within the framework of a given zoning or spatial plan, you as individual, as company, there is a relatively clear process that you have to follow. There is clear rules. There is, as it seems, also a fairly manageable time frame for things to be achieved, which of course gives legal certainty to people who want to know what they can do. Things seem to be a bit different when, let's say, a change of the zoning would be required, a change of the spatial plan. Of course, that would not apply for only minor changes of use of a given property when you want to convert, I would imagine, a hotel into apartments or similar. I think this would not be the case. But let's take the example of this odd shopping mall that is basically outside the city boundaries of, let's say, a city like Zagreb, where it is seen that, well, leasing goes poorly, and there is an increasing level of vacancies there, so that you, as the assumed investor, owner of the project, think about alternative uses and want to put, let's say, a random example, a medical center in. You have the idea to also combine it with a hotel, and maybe you even combine it with some whatever apartments, but really just a random example. So that you would clearly have to change the zoning of this given area to achieve your purpose. You don't have the possibility then under Croatian law to enter into a contract with let's say the municipality, the city of Zagreb, allowing you for the rezoning under certain conditions. You would have to go for, let's say, the legal act of a change of the zoning plan, which is like the legal process to enact a law in a certain sense. Would that be correct?
Yes, that is correct. Unfortunately, Croatian law does not set out such a possibility of contractual relation. Only to the owner or to the investor is left the possibility to submit the proposal for change of the spatial plan and to initiate that procedure.
And of course, you are then, and there is this process that you have described, but ultimately you are, bluntly speaking, at the mercy of the authorities.
Something like that.
Or not to do what you achieved. Yeah, that's interesting, because as kind of there is an increasing count of countries where I would say where there is such contracts, however you would want to call them, urban planning contracts or other things, that give this additional possibility for investors to achieve their goal and combine this in a kind of a win-win situation also with the interests of the authorities. Anyhow, but this is a possibility that is not yet, or not at all, maybe given under Croatian law. So thank you very much, Marija.
You're welcome.
Great summary of Croatian law. Now moving across borders, stepping into Serbian territory. Marko from our Serbian real estate team. Marko, how do things work in Serbia in contrast to what we heard about Croatia?
Well, first of all, thank you, Peter, and hello, everyone. Also, I want to first thank Marija because her very detailed presentation actually left a job a lot easier for me here because, as I noted from her presentation, things in Croatia and Serbia are quite similar in respect of change of use. We have similar procedures, similar issues, and similar, let's say, deficiencies or practical problems, which maybe make this process more difficult than it is on paper, let's say, or when you look at the relevant legislation. But let's start from the beginning. When we talk about change of use of existing buildings, which is here the topic, first of all, we have to mention that the use or the purpose of the building is actually determining all construction-related permits issued for the relevant building, starting from the location conditions, which is basically the first official document obtained by investor who wants to construct that building, and it's basically derives from the zoning regulation and develops further some limitations, some let's say conditions for constructing that building. Further on, we have a construction permit, of course, which is the most important document regulating the entire construction phase, and finally, in operating permit, the use is determined regularly in a way which it has been determined in all previous construction-related permits. Now, as mentioned, the use of each existing building is determined by the document, and it's usually, let's say, in most cases, in line with the zoning documents. And depending on particular complexity of each building, it brings along several, additional requirements related to, depending on the complexity of the building and its extended use. It also implies several maybe more restrictive conditions in respect of fire protection, complexity of design documents, and so on and so forth, which is all relevant for change of use because all these conditions will practically have to be met if the purpose of the building is going to be changed. Now, in Serbia, as mentioned, change of use is possible. It has been present, let's say, since forever in Serbia. However, we can say that in practice, it was not used that much, maybe for some more common changes, such as from office to apartment and backwards, depending on what the owner would like for it to use it or to rent it for. And another issue is that people, in Serbia, usually some people just don't change the use for these simple changes without construction works and so on, because let's say the practice of competent inspectorates are such that they do not usually check this stuff. However, as mentioned, because this new crisis, let's say COVID crisis, made this issue much more relevant even for more complex structures such as shopping malls or hotels, maybe this practice of inspectorate in Serbia would also change. For example, it's unimaginable that somebody just changed the use of shopping mall to storage room and just leave it as such, and nobody cares. So yeah, this will probably be more relevant in the future. Now, in this second slide, I see that we mostly cover this issue. So yes, change of use is possible, and of course, the intended use would have to be the one allowed by the zoning document. Now, when we say allowed by zoning document, zoning documents usually do not set the single purpose for a single location. There are cases like that, but usually there are several compatible uses which could be let's say awarded on a location, and as long as investor is shifting between the compatible uses allowed by zoning document, he should be fine in the process of repurposing of that building. And of course, if not, then we have the entire complicated process of amendments, which we will discuss briefly at the end of this presentation. So when we come to the process of change of use, it's fairly regulated by the law. It's the law on planning and construction in Serbia and related bylaws. It's quite straightforward procedure. There is not much room for case-by-case assessment because the role of competent authorities is such that if they receive all relevant documents which are prescribed by the law or bylaw, which are confirmed by engineers or other experts, let's say, they do not have room to just, disregard that things, and they just have to follow the document procedure and to literally check box if everything is in place. Of course, one of the things that they are checking the process is whether the intended use is allowed by the zoning document. Let's say the rules, which are, as I mentioned, the rules are quite clear, and discretional power of authorities are excluded. And that's the case again for regular change of use within the compatible uses prescribed by the zoning document. Whereas if we have to undergo the procedure for amendment of the zoning document, that leaves significantly much room for discretion of authorities, because they formally always initiate that process, and they formally, at the end of the process, adopt the decision by which the zoning document enters into force. So, in addition to discretion of zoning of relevant authorities, there is also a wide possibility for public scrutiny of the document, of proposed document or amendment to the document, which, it depends on intended change. For example, in practice in Serbia, we had some projects which were already, let's say, agreed formally or informally between the city of Belgrade, for example, and the investors. They prepared some preliminary changes or proposals for amendments of the zoning document, which, for example, were aimed at repurposing of one part of let's say, a forest which is within the city of Belgrade, and it raised so much public concerns, noise, and objections that basically the already, let's say, pre-agreed investment and the project was halted before it even began to enter the formal process of amendment of this document. So this process, however, it seems like, yeah, authorities could always, find a way around. Sometimes the reaction of that public scrutiny process is such that they just decide to set aside the proposed amendment, and then investor could be at problem. So, as you may see from all these slides, the main problems are not in the process of change of use of concrete building, but in previous process of amendment to zoning document if necessary.
Mm-hmm. So, if I may just briefly interrupt, Marko, I take it that this is, of course, as always, where ultimately this is a process that can be compared to the enactment of laws, right? Which is basically a zoning plan is a certain type of a law, rather than a private legal act. It has political components clearly, and political aspects have to be considered. Now, just to maybe tie into the questions that I also had to Marija, which is our observation that this is kind of increasingly employed by certain legal systems. These are kind of contracts between private individuals or companies and authorities, prescribing under certain conditions, of course, and within a given legal framework, to interfere, quote unquote, with the existing zoning and to have zoning changed, altered to allow for certain deviations under certain conditions. Is this something that Serbian law has legal instruments for? Is there legal provisions allowing for this, or is this basically unknown? And is it comparable to what we heard about Croatia, where it is really kind of you can instigate such process, you can ask for it, you can kick it off basically, but then the process is in the hands of the authorities, and ultimately you have to live with whatever the decision is ultimately, of course, with certain legal constitutional rights and remedies, etc., etc. But ultimately, it's like, as I said, the enactment of a law, rather than something that could be agreed upon. How is this under Serbian law?
Well, yeah, and Serbian law is quite similar to Croatia. It is always a process before the local authorities, local parliaments who adopt changes to zoning document. There is a procedure and so on and so forth. In preliminary stage, let's say, there is a possibility for investor to conclude the agreement with the authorities on, let's say, financing or co-financing, joint financing of these amendments to zoning document. That is legal category. I mean, it's expressly prescribed by law that, I mean, in Serbia, everybody can informally propose the changes to the zoning document. However, formal proposal always comes from a, let's say, local authority or commission formed by local authority, working group, or something like that, with the exception that private investor who concluded the financing agreement with the local authorities is authorized to propose these amendments. So it's, I mean, it's like preliminary agreement, which forms a form of partnership between, let's say, local authorities and an investor for them to cooperate in that process. I mean, it's not development agreement, it's not spatial planning agreement, which would by per se amend the document. But it may be expected that in that process, local authorities will be far more, let's say, cooperative. It could be much quicker to achieve the amendment. However, there is no possibility at all to exclude the two most important parts in which the process can go wrong for investor, and that is public scrutiny procedure and expert control. This is part of any adoption of new zoning document or amendment to the existing ones, and it may lead to significant changes to the draft proposed by investor. And then there is a question whether investor would at all want to implement this amendment draft. It can, again, recycle some parts of the procedure. So, for example, you have 2 or 3 public scrutinies if the comments and objections during that process were of that extent to significantly and substantially amend the proposal. So, yeah, we have kind of agreement, but it's still the process of adoption.
Yeah, I understand. It's rather a procedural type of agreement than an agreement in substance. So, I mean, I would summarize the situation basically similar to the situation that we heard about Croatia before. As long as you, as an investor, as a company, are moving within the framework of your spatial planning, zoning plan, things are quite clear, of course. I mean, there's always risks with any type of application process, but there is a kind of a relatively safe legal framework for this type of process. But of course, should you need change of the zoning, then you are on thin ice, basically, ultimately, and the outcome is open, and it's basically a political process that, I mean, it is clearly there is legal framework, but ultimately it's a political decision.
It's political decision, and
whether or not
it's in Serbia
possible. Yeah.
Just that in Serbia that goes usually, I mean, if it's not some major problem for the public, it goes smoothly because, as you know, probably in Serbia, we on all levels are, having the, let's say, stable local and regional, local and state government. So, I mean, usually it will not be a result of some voting over in the parliament. If you agree with the local, preliminary agreed with the authorities, you will, usually that document will pass. At least the first phase, but again, control and scrutiny could shift that.
And fortunately, I think the situation will be that when your project is good, when it is not kind of not in the public interest, like cutting down forests and other things that may not be that popular, you may have the benefit that good investors hopefully always will have, that authorities may be supporting you in your project. Thank you, Marko. I think that was also a very good summary on the Serbian position. Clearly, within the given time frame. So for all details, we will have to give our audience into your hands anyhow. Now, the final stop of our journey today is Slovenia. Such as all the countries that we speak about, basically a small country, but a country that has been shown to be of quite some interest for investors over the past years, with real estate playing a substantial role clearly in all that is going on in the economy. So Neža, having heard about the situation in Croatia and in Serbia, how would you kind of summarize or contrast the situation, the legal situation, and the procedural situation as we have it in Slovenia these days?
Thank you, Peter. Firstly, it's an honor to participate in this webinar also for me. And with regard to situation in Slovenia, I think my job is quite easy because it's quite similar to Croatia and Serbia. So let's just go quickly. What is actually the legal framework for use of the real estate in Slovenia? It's the Spatial Planning Act that determines what is the use of the real estate, the property. And with regard to the buildings, then the Building Act is applicable. And actually, the use of the building is determined in the issued building and use permit. So for the purposes of changing the use of the property of the building, then the building and use permit needs to be changed. The new building permit needs to be obtained. And in the procedure for obtaining the new building permit, then the administrative unit reviews if the state and local spatial plans are allowing the use of the intended use of the building. So in summary, the change of the building, the use of the building is allowed and is achieved so that the investor or the owner of the building submits an application to the administrative unit with stating that the new intended use. Also, it needs to submit a detailed design of the building, or if only a part of the building is intended to change its use, detailed design for this part of the building. And this is made by an architect or a construction engineer. Then the administrative unit reviews the submitted application, and if all the documentation is submitted, then the building permit should be issued within 2 months of the receipt of the application. After the final building permit is obtained for the new use of the building, then also a new use permit needs to be obtained. And for obtaining a use permit, a construction expert's report needs to be also submitted to the administrative unit. And it should state that the change of use has been carried out in accordance with the construction permit and that all the requirements are met, like fire safety, mechanical durability, and also noise protection, and so on. And as already mentioned, the new building permit should be issued within 2 months from receipt of the complete request. But also in some cases, if additional consents of the authorities needs to be obtained, such as Ministry of Consent or Institutes for the Protection of Cultural Heritage, in case that the building is located in protected areas, then this procedure can be prolonged, but only for 1 month additional. So the building permit should be issued within 3 months from the submission of the complete application.
I mean, this is, sorry to interrupt.
Yes.
This is really very, I mean, this is impressively short. And as I have to say, in comparison with, for instance, our legal system, in comparison with other legal systems in which we operate. So this shows quite a, I would say, maybe a service-oriented approach towards such filings.
Yes, but you need to take into consideration that this is a deadline in the law, but you know, it's case by case, also depending on the workload of the administrative units and when.
So you mean this is on paper and does not always comply with reality?
Correctly, yeah.
So what is the?
But usually within 6 months, the new building permits should be obtained.
Yeah, which is still quite okay, I would say. Yeah. Well, that's, I think, yeah. As you had mentioned, Nisha, I think and I think it's not that surprising that, I mean, you have at least you have common history. We have a common history in the countries that we spoke about today. And of course, administrative provisions, when they are well tested and when they have operated for a long period of time successfully, there is not that much reason to interfere with them and to change them. So I would say, at least for me personally, it's not a big surprise that we don't see tremendous differences between the general approach that is followed in Croatia, in Serbia, and in Slovenia, because, as I said, there is in the undeniable common history, yeah, I mean, these things usually date back for a substantial period of time. Such administrative bodies of administrative law. To tie into maybe my question that I already asked for Croatia and for Serbia, the use of contractual kind of instruments to kind of as a, I would say a safety ventil to a certain extent, or as a kind of a new route to facilitate changes of zoning plans. Is this something that Slovenian law knows?
No, also in Slovenia, we are not familiar with these contractual ways to change the zoning. Only possibility is if a certain area is developing that isn't developed yet, then the investors conclude on communal infrastructure agreements with the municipality in order to speed up the process of development. So the municipality doesn't construct the communal infrastructure, but the investor itself builds the infrastructure and also covers the fee of this. But otherwise, no.
Right. I mean, that's interesting. I probably it could be the case that I mean, this is nothing to speculate about, at least not on my part, that obviously there isn't a need for such instruments in the past. It also, I think it has to do with the level of activity that is going on in development and construction. Clearly that such ideas are being generated when there is much development that is
Rightly.
development that is going on, because otherwise there is no need to deviate from tested processes. Well, I think the interesting thing for the years to come will be to observe whether or not the developments that we currently see, and also the aftermath of the crisis that we are just hopefully successfully navigating through in its final stages, the COVID crisis, leads to additional need for changes in this field as regards repurposing of real estate. Because I mean, one of the general points of concern clearly is that we will notice the only with a certain backlog what the real effects of the crisis on real economy were. So where the bankruptcies and insolvencies that hopefully will never occur to such a dramatic extent are going to happen, and where there might be the need to do redevelopments on a larger scale. And clearly, I mean, this could be the case when there is larger impacts on, for instance, urban retail or other elements of real estate that require more dramatic changes than are currently going on. I think we are basically at the end of our rainbow of today, of our tour d'horizon through 3 important countries on the Balkans. Thank you very much to the panel for your interesting presentations. I had forgotten to mention, didn't do that on purpose, that you would have had the possibility to ask questions in the chat function. We still have a few minutes of time to allow for this. Should there be specific questions on the part of our audience that you would want to share with our panel or with all of us, please feel free to employ the chat function. Otherwise, all of our experts today are, of course, you see their contact details here on this final slide, and you have our email address, and you know where to reach us. We all will be happy to answer all follow-up questions that there may be, or of course, when there is the need, to answer your questions in concrete legal topics that may arise for you. Other than this, I would like to thank you for your attention, and to thank our panelists for sharing their expertise with us so wisely today. We are just in time. It's 1 hour now. We wish you a very successful rest of the day, and thank you again for having attended our webinar. Goodbye.